impedes the police in their investigative operations does not prevent the police questioning the value of the rule that interferes with the performance of their duties.
I think we want to recognize this, too, that the Supreme Court, only a few years before the Escobedo case, upheld the admissibility of a confession obtained when the police denied the suspect access to a lawyer. Now, in the Escobedo case, in effect, they're overruling the previous decisions, 5-4 decisions. Here again, the police are left in a dilemma. What is the rule? What is the rule today? Look what it was yesterday, and they tell us now that no longer holds. And somewhere along the line, they've got to be given this opportunity to interrogate criminal suspects. You just
could I ask
can't
you
get
a
by
question
without.
about this? You've written a very influential book on how suspects should be interrogated. You put a great stress on the need for privacy in the interrogation of suspected offenders. And this is one thing that the Escobedo case was about. If there's a lawyer there who, and he violates this privacy in a sense that you are demanding, and yet he also gives the public a certain scrutiny over police procedures. It's been suggested that that interrogations could be private but not necessarily secret. And I find this a very interesting suggestion. That is, for example, they could be tape recorded and reviewed by some sort of a board who could thus check on police procedures. You would have your private interrogation, but you would also have a review by some other independent agency. And I wonder what you would say about that kind of a notion.
Well, if you leave the police interrogator in the room alone with the suspect, I'm for whatever you want to do to safeguard against brutality. That's all right, but you've got to have that privacy. But remember this, once the lawyer enters upon the scene, that's the end of the interrogation. He's not going to sit there and say, well, you go ahead and tell these people the truth. I'll stand here and watch that they don't beat you up.
Doesn't the individual have a right not to say anything to the police whatsoever?
Yes, but he doesn't have the right to have, at least until this decision came along, doesn't have the right to have somebody present in the police station to tell him don't talk to the police.
Well, then who will inform him of his right?
He has the right, and the police will inform him of his right, but an inbound trained interrogator, without using any force, can con him into talking anyhow, and he has certain sections of his book on how to handle the pesky fellow who pleads the Fifth Amendment, and it's a very clever way to open him up. Now, this is really, I mean, isn't that a fair statement?
Yes, but what's wrong with it? These techniques are designed to get the admissions from the guilty and not to get admissions from innocent people. And it seems to me we're losing sight of this. We're looking at this out of its proper perspective. What are we seeking to do? We're seeking to protect society from the criminal element. Now, we're turning it into a sport where you get this individual here now and they'll say, all right, we're going to trip the policeman at this point and we're going to handcuff him over at this point. Now, play around this ring with him here. This matter of crime detection, crime prevention is not a parlor game. And I'll tell you this, if the public is willing to pay the consequences for these restrictive rules, as long as they know what they're getting into, what the consequences are. If they make an intelligent choice, all right, it's their business. I happen to live in a neighborhood where it's safe to walk around. I'm right off of Michigan Avenue. I don't have to worry about it. My children are out in the state of Washington. They're kind of safe out there in cowboy country. But the people that I want to have some some information upon which to make an intelligent judgment are those who are living in the big cities where there is a serious crime problem. And if you tell the police that they can't interrogate anybody unless there's a lawyer there who's going to tell him to keep his mouth shut, we're going to have a lot more crime in this country. There's just no question about it, because most crimes can't be solved except by interrogating suspects. Take the case of a man who's hit on the head at night, his skull fractured, his wallet taken away from him. No one witnessed it. He didn't even see the guy who hit him. A woman dragged in an alley and raped. At night, she had a very vague description to give the police about this man. Now, how in the world are they going to solve those problems? For several years, I was director of the Chicago Police Scientific Crime Detection Laboratory, and I will tell you this in all sincerity. You could bring the whole laboratory staff there and the whole laboratory equipment, and you're not going to find evidence at that scene, at the scene of those crimes, which can be used as a lead or for the purpose of convicting somebody, you've got to question criminal suspects. Am I right, Superintendent?
Absolutely. You
I
see,
don't think this is not exactly the question. You have the right to interrogate criminal suspects, but the question is, does the man have a right to have a lawyer to warn him of his constitutional
All right.
Well, he won't talk if he has the lawyer
In
there
other words, you would
telling
then say
him-
he cannot have his constitutional right.
Well, now wait,
Well,
you're talking
this
about
is a constitutional right.
the Constitution. The only thing the Constitution provides is this, and I'm going to give it to you verbatim. In all criminal prosecutions, the accused shall enjoy the assistance of counsel for his defense. There isn't a word in the Constitution that a man at the time he's picked up by the police is entitled to a lawyer. The court in the Escobedo case read it into the Constitution just as they've been reading a lot of other things into it.
Well, if I may comment on that. First of all, historically, there was no police force to speak of when the Constitution was written. Until the 19th century, certainly, nothing much happened until the trial. This is a point made in a recent note in the Yale Law Journal. So that one may say that the Founding Fathers contemplated that counsel should only appear at the trial, but it's also fair to say that nothing much happened. There was no focus. It was not crucial until the trial. Now, since those days, we've developed a professional organized police department. The crucial stage is before the trial. Most cases, I think it's fair to say, are won or lost before the trial. Now, one can argue that the history is illuminating. One can argue that if the Founding Fathers contemplated giving counsel when it was important, when the focus was on the defendant at the trial, today, when the focus has changed, the right to counsel should change with it. Now, I want to say this. I'm not one of these people who, or at least I try not to be, one of these people who answers a police officer who is trying to solve difficult problems with the statement, the Founding Fathers made the choice for us. I know darn well that more often than not, the Founding Fathers did not, and that within the broad confines of the various Bill of Rights, we have to decide these things in light of modern-day conditions and current policy problems.
All right, could I ask you a question, Yale?
Yes.
Why then, let me ask you this, in the light of all that you've said,
Yes.
what do you think the police can do in situations such as I've just described? What should they be permitted to do where there's a woman dragged in an alley and raped, man hit on his head on the street at night and robbed? Now, what authority, what power would you be willing to give to the police? How can they solve that crime by your standards?
Can I answer that this way? I'm not prepared to say, and I really don't know. This is a very difficult question for me. I spent many weeks kicking it around and haven't got a clear answer as to whether the right to counsel should begin at the moment of arrest. I think I can say this much, that there's been a great exaggeration, or at least there's reason to think that there's been a great exaggeration as to how many hours, how many days the police do need to interrogate. I've heard statements made, 72 hours, 48 hours,
Well, here, should they be
24
permitted
hours.
to do it at all? That's what I
Well,
want to ask you.
I have a much more difficult time if someone says 2 hours, 3 hours. I think at that point, you're minimizing the possibility of coercion. You're minimizing the dangers. The point I'm trying to make is this, that it can be done in 2 or 3 hours, or at least testimony by David Atchison, who is the U.S. Attorney for the District of Columbia, which bears the brunt of the McNair-Mallory rule. He says that at the present time, if a suspect can hold out for 2 hours, 2.5 hours, he is pretty well in the clear, but very few of them can do so. Now,
Yes, but Yale,
Yes.
According to the Escobedo decision, if this man says at the outset, I want a lawyer, or if some lawyer shows up there, the police are not going to have 2 hours. They're not going to have 10 minutes. That's the end of the interrogation. Now, how can the cases such as I've just described, those two hypothetical case situations which typify the crime problem, how in the world are the police going to solve that?
Well, one statement is that obviously there are some they won't solve.
There are many they won't solve.
Well,
this is your typical crime,
but
and you
no.
can't solve it by other means.
I don't think that there are many. It seems to me, again, I go back to the testimony of David Atchison, there are very few cases where a man got off completely because of the McNabb-Mallory rule. There are many cases where he was convicted of manslaughter rather than murder, or unauthorized use of a vehicle rather than robbery. Now, he says, in a case like Kilo, where you have a man who will hold out for several days, there is just no way we can cope with the situation.
No, but in the Kilo case, that case in Washington, D.C., is not one where the court reversed the conviction, the Court of Appeals in the District of Columbia, because they said that this was not a voluntary confession, it's not a trustworthy confession. They reversed that conviction. They reversed it on two occasions, three occasions, in fact. They reversed because they said the police delayed in bringing the arrestee before a committing magistrate, a federal commissioner, for the so-called arraignment. Now, when it came back for trial the final time, the trial judge in that case, Judge Hart, had to direct an acquittal of the defendant. Now, mind you, the defendant had confessed to murdering his wife. He led the police to the place where he'd thrown a body on a garbage dump. Now, because the police did not comply with a court rule saying they had to bring him in immediately, or with the decision in the Mallory case, the confession was not usable as evidence, and that man was released. And here is what the trial judge said when he had to instruct the jury to return a verdict of not guilty. I will direct a verdict of acquittal, and I do so with a heavy heart. In fact, it almost makes me physically ill. Felons will sleep better tonight, and the public will have new apprehensions for its safety. Now, you said not many of these people go off free. Here's one of them who did. It's very recent, just the other day.
I'll comment on that. I might say parenthetically that for my money, that was a rather unfortunate statement for the trial judge to make. I think he builds the image of being a fearless fighter against crime and believing in law and order, but I'm not sure that he's doing the job of a judge in that case. It seems to me that under the circumstances, that was not such a radical departure. Under the circumstances, this had to be done. It seems to me the police bungled the Kilo case at every step. They arrested him without probable cause. They searched his dwelling house without bothering to obtain a warrant. They held him 34 hours in
But he killed his wife and told him where the body was.
But, Fred, there are rules. And we are not just waging war, all's fair in love and war. There are rules. Now, how can these police violate this man's rights at every turn and turn around and blame it on the court?
Who made the rules?
That seems to me a separate question, Superintendent.
No,
how would you feel?
You speak about rules.
May I ask? It is the law. You must obey the law until
it's
changed.
Who made the rules?
This seems to be getting a little bit away from the issue.
The law is made by the legislative bodies. We're talking about man-made rules. I would like
there
to
are
ask
also
you,
men in the legislature.
Yes, but these are laws. I'm
When the
speaking
Supreme
about,
Court speaks, it's not the law?
I'm speaking about judicial rules. They're not legislated into law. They are made law because they are judicial
In a particular
decisions.
case situation.
But let me ask you this. Do you feel that it's socially important that guilty people be found guilty?
Of course it is. But it's also socially important that we implement and effectuate other rights. It's socially important that guilty men are found guilty, but still we have the attorney-client privilege, which obviously keeps out the truth in some cases. We have the priest-penitent privilege. We have the doctor-patient privilege. There are a great many things we've had for hundreds of years which go to keeping out the truth. Obviously, we make the decision that there are other values in life, in our society, than simply apprehending the guilty.
On that point, excuse me, there are other issues, other points in this whole question of police powers, and I think this brings out one of them, the other values that we're trying to obtain at the same time that we're trying to combat crime. Superintendent Wilson, in an article that you wrote, you said, and this isn't an exact quotation, but if a suspect is unwilling or unable to explain satisfactorily his actions or his presence, police should have the right to take him to a police station and hold him for a period of 2 hours without placing him under arrest. Now, I think this brings into question other rights, and I would like to ask Mr. Gilman.
I would
first,
like to
or ask you
have
first
this
to comment on
elaborated
this.
a bit. I think this man was found in an alley. It was a hypothetical case. In an alley at 3 o'clock in the morning, under circumstances that aroused the officer's suspicion.
And if a man, if one of us or another person is walking along the street at night and he does not want to explain his presence to a police officer, do the police still have the right to take him to the police station?
I think he has a responsibility to explain.
Yes, but if he
to the
does
police.
not, then what?
All of the circumstances must be taken into account.
But then who
when
decides what are the
the
reasonable
officer,
circumstances?
I would say the officer.
And
He
is there
must-
any review of these procedures?
Well, certainly there will be a judicial review in the event there is a charge.
And if there is no charge, because you say
The man will
without
be turned
placing him
loose.
under arrest.
If there's no charge, the man will be released.
Well, if I might just make a point about the man being released, it is true that in a particular case, in a celebrated case, the man may well be guilty. I don't deny this. I don't deny that there are plainly guilty people who are going off scot-free. But the point is, all those who are not guilty, who were the victim of the same sort of misconduct, never got to the court because they were not guilty. Now, a recent study of arrest for investigation in the nation's capital disclosed that of every 18 persons arrested for investigation, 17 out of the 18 were later turned loose. The court only gets the 1 out of 18 where the man was charged. And if it says you shouldn't arrest them under these circumstances, one might say it's freeing a guilty man. But one might also say it hopes thereby to prevent the 17 out of 18 from being arrested for investigation the next time.
But if the courts, if the legislatures authorized the police to detain somebody without arresting them, we could avoid some of these formal arrests. People wouldn't have a formal arrest charge placed against them. Now, when you talk about stopping citizens on the street, let me use two illustrations here briefly. If I'm walking down Michigan Avenue at noon and there's been no crime committed right there, I would resent a policeman coming up to me and say, "Who are you? Where are you going?" His request under those circumstances would be unreasonable. On the other hand, if I'm taking a shortcut through an alley at 3 o'clock in the morning and some policeman stops me and says, "Who are you and where are you going?" I think I'm under some social, moral obligation to answer his questions. I think his actions in that circumstance is reasonable. And fellas, let's bear this in mind. This is how the police solve crimes and how they prevent crimes from being committed. Now, if we want all of these individual civil liberties, all of these rights, where we don't have to talk to a policeman, fine. If we recognize what the consequences are. If the police can't do these things, we're going to apprehend less criminals, crime's going to be more profitable, and it looks to me that we can't afford this luxury too much longer with crime increasing 5 times faster than population as it is. But if the public wants this, all right. But just let them know what they're getting.
There you go again,
By way of side effect.
blaming it on the courts.
Wait, I would like to ask one thing here.
Sure,
a lot of this,
increased.
a lot
So
of
what?
the,
I mean, it seems to me this is a very important point. Crime has increased 5 times faster than the population.
And you blame it on the police.
No, I don't blame it on the police. I'm very careful to say that it's just as wrong to blame it on the police as it is to blame on the courts.
I'm not blaming it all on the courts.
Wait a minute. I simply point out that crime has increased almost as rapidly in England, which does not have the same restrictive set of rules. I point out that crime has increased faster outside the District of Columbia than it has inside. And inside the district, we have the most restrictive rules in the entire land. Now, the implicit theme here is that we cannot afford a civil rights binge. We cannot afford these decisions because these decisions are contributing immensely to the crime problem. I don't think there's any solid evidence of it. I point out that Superintendent Wilson, the last time I read the Chicago newspapers, had cut crimes against the person 21% in the face of all these handcuffing court decisions.
That was before Escobedo you're talking about.
Well, it was before Escobedo, but it was after Wong's son, it was after Maffei, Ohio, it was after Haynes, it was after a great many cases which have caused police spokesman to act as if the world were coming to an end. And here we find that crime is being cut.
Very, very slightly.
Do you
very
think,
slightly.
for example, that the chief in the district is his crime rate is increasing because he is hampered by the Mallory decision at the present time?
I'm surprised if it is not. I don't know what the true facts are. But if I understood you correctly, you said a moment ago that England has greater restrictions on their
No. I said that the point was that England, which does not have similar restrictions on its police, has still experienced a comparable increase in crime.
I wonder what it would have been otherwise.
Well, but the fact that it's experienced a very sharp increase in crime suggests that the reason for the increase is not the McNabb-Mallory rule, is not Escobedo, is not Mafia, Ohio. They don't have such cases. It indicates one thing, that all of this may simply be, or much of this may simply be, an increase in crime reporting. That there is better reporting, more uniform reporting, more centralized reporting. There's no real increase in crime.
Yale, if I may be persistent in this, could I ask you again a question? I would like to get a very frank answer from you. How are the police going to solve the kinds of crime I referred to before if they don't have this interrogation opportunity? Now, we can forget about statistics. We're talking common sense now. I want to know just what you and some of the people who share your views, what are you willing to concede to the police in those situations? I think it's important that we face up to that.
I certainly think that is not a question that can be answered yes or no. I have never said that the police should have no time to interrogate. But I want to point out that the battle has been until recently 36 hours, 24 hours, 48 hours. Now responsible law enforcement authorities are saying maybe the job can be done in 4 hours or 6 hours. I think that obviously as we reduce the time desired, the time asked for, the case for not giving this to the police gets weaker. The opportunities for coercion, etc., get weaker. Now, one other point. I think let's not overdo this Escobedo thing. Escobedo cannot be blamed for the current situation. It's too new. It's only 4 months old. Now, there is sweeping language in Escobedo, but I think you know as well as I do, there's also limiting language. And you know as well as I do that that limiting language, he was not warned of his rights. He made repeated requests to see his attorney. His attorney outside made repeated requests to see him. That limiting language will not be missed by many lower court judges. I think what the court was trying to do in Escobedo was to encourage pre-arrest interrogation. I think perhaps it was influenced by the fact the FBI is supposed to make wide use of pre-arrest interrogation. That is, interview people, talk to people without giving the individual the stigma of an arrest. I don't know the answer to that one, but I think that these are the kinds of questions we should be grappling with. We should not be shouting the court has no power to police the police. On the other hand, we should not be shouting you don't love the court, you don't love the Constitution if you criticize anything the court has said. The court should be criticized. I'm not prepared to defend everything the court has done, and I'm worried. Two things, that the excessive criticism of the court may create an emergency atmosphere. We can't afford a civil rights binge. But I'm also worried that the excessive criticism of the court will evoke excessive praise of the court, will drive legitimate, informed, scholarly criticism of some of the court's decisions underground. And we certainly shouldn't do that either. I think now we're getting to very tough questions. They're hard questions. The collision of opposing values is great, and it's not something that one can answer yes or no.
Well, of course, if the policemen watching this program, as I presume they are, and they're searching for an answer to this question, I'm afraid they're not helped very much by what you've just said as to what they can do when confronted with cases of the type I described. The man who's hit on the head and robbed, the woman who's dragged in an alley and raped. What can the police
Well,
do?
I mean,
They've got to know, you
There has
see.
to
They
be more
can't...
facts than that. The woman is raped now.
Yeah, I'll give it to you very simply. Let's take the one case of the man walking along the street at night, going home. Someone hits him on the head. He doesn't see who it is. His skull is fractured and his wallet is missing when he's found on the sidewalk. Obviously, he can't help give the police a lead as to who did it. No one else saw the crime. Now, what are the police going to do? Now, what they do now is look around for a likely suspect, pick him up for questioning. Now, that's the only way they can solve those crimes.
Well,
now,
if you mean by picking him up, bringing him down to police headquarters?
For questioning, yes.
Well, then
They can't interrogate him in his parlor when his wife and children are there.
They can, but...
I mean, you're not going to get anywhere with the questioning of a person under those circumstances.
It seems to me you've raised a situation where the police do not have probable cause to arrest anyone. I mean, they just can't round up people hoping that somebody will confess.
I wasn't advocating that.
Well, you say that they don't have any real...
I said a likely suspect. That implicit in that was that they've got some good reason to believe this fellow might have done it.
But something less than probable cause within the meaning of the Fourth Amendment.
Why, certainly, they can't just on suspicion bring this fellow in and charge him with a crime. The court would laugh him right out of the courtroom.
Because there was no probable cause.
No probable cause, certainly, to try him for the offense. And at that point, they don't have any probable cause to present a case against him. But they've got good reason. Here, let me suggest this. Here's a fellow that was seen in the neighborhood, let's say. The police get a tip the next day. Joe Bloke was seen in the neighborhood. All right, they check and find out Joe Bloke has a record for robberies. Well, it seems to me they ought to be able to pick up Joe Bloke and question him as to his whereabouts at the time of the crime.
Could I ask a question here, Mr. Goon, because I think this is very relevant to the point that Mr. Imbau has been raised and some of the other points that we have raised. Much of what we have talked about is going to be dependent on the good sense and the discretion of the police officer, trying to find his way through a very complicated set of rules. And I'd like to ask you, what is being done now in police training schools to help officers solve these kinds of issues?
Well, both in the police academy programs and in the academic programs, the police officer is given a great deal of criminal law, criminal evidence, and criminal procedure. However, the problem of the student in those classes is somewhat different than the student in the law classes, because this person who is going to enter police work is going to be put out into a field situation, and he's going to have things arise which cause him to make an immediate decision, a decision to talk to someone, a decision to interview someone, to interrogate someone, to arrest someone. And he has to make a split decision out in the field. He doesn't have ample time for scholarly research. He doesn't have ample time for discussion. He doesn't have the time that other people will have later on to review the facts in the case. Our students are constantly asking questions of our legal instructors, very precise questions, factual questions, and the instructors can only answer, this is what the law is, this is what the courts have decided. But very often they have to say, you must use your own discretion, you must act in good faith and wisely, and you must trust that the courts and society in general will back up what you do. Well, this is very difficult for the student. I think what we need is a great deal of clarification in these areas of arrest, of seizures, of admissions and confessions, guidelines laid down, very practical guidelines for the officer in the field that he can use. I think the American Bar Association has a responsibility. I think that the courts have a definite responsibility for clarification here. I don't believe that lawful enforcement of the law will encourage crime, and I think most police officers would very much like to do their job in a lawful way. But sometimes the police officer just doesn't know when he takes his action how the courts will evaluate that situation and that particular occurrence. We have statements made within law enforcement circles that are very, very good in this regard and some that are not so good. For example, a very leading law enforcement spokesman said recent court decisions placed the policeman today on the horns of a dilemma. Either he abides by the prescribed rules and renders ineffective service, or he violates or circumvents the rules and renders the service required of him. I think that's an oversimplification, and I don't think myself, in my judgment, that a police officer has the right to decide to violate or to circumvent a rule knowingly. Another chief of police has said that in severely limiting the powers of the policeman, it is anticipated that the policeman will ignore these legal limitations when the immediate public welfare appears to demand police lawlessness. Again, I think this is a bad kind of a statement to make. I see myself no contradiction between a police officer being a firm supporter of the Bill of Rights and the Constitution in doing his job, and a very, very good law enforcement officer interested in investigating crime, apprehending offenders, prosecuting cases wholeheartedly. I think we need more statements in police circles like made by Quinn Tam, who's the executive director of the International Association of Chiefs of Police, and he recently said that the community will judge law enforcement as a profession when it finds that law enforcement has a rock-ribbed, unwavering preoccupation with and interest in civil rights and liberties. This is what yet we do not have, in my judgment, in law enforcement circles. Either in some law enforcement circles, if you talk about the Constitution and Bill of Rights, you are suspect. And I don't think this is a healthy situation, but not in all police circles.
Well, gentlemen, I would like to thank you very much for what I think is an interesting and valuable discussion. Mr. Wilson, Superintendent of the Chicago Police Department, Professor Yale Commissar, Professor of Law at the University of Minnesota, and currently visiting professor at the Harvard Law School, Professor Fred Imbaugh, Professor of Law at Northwestern University, and Professor Gurman, Professor of Police Science at the California State College, Long Beach. Our society has long recognized that in seeking to punish the guilty, we may punish the innocent as well. It's a very uneven struggle between the individual suspected of a crime and the state with all its power. And so we have surrounded the suspected offender with many rights which curb the activities of the police, all in the interest of justice. For centuries, we've been guided by the tradition that it is better to let 10 guilty go free rather than hurt one innocent man. And we do undoubtedly let guilty men go free at times. But we must recognize that this is a necessary price we pay for a free society. There are some people who argue that we have curbed the police too much. We no longer need to fear a tyrannical government, it is said, and therefore the restraints on the police are unnecessary. I think it's important to remember one thing, however. In our large, complex society, we have many bureaucratic organizations which are absolutely necessary. These bureaucracies are not a threat in the sense that they are staffed by vicious people, but they can be a threat, I think, because they can run right over individual liberties through sheer indifference or a short-sighted goal of efficiency. And so the threat to individual liberties may still be there, even in a democratic society. In any event, in a democratic society, the police are supposed to be the symbol of law and order, of a just law and a just order. If the police become other than that, if the police become a symbol of brutality or unjust authority, our democratic society will have been radically transformed.
Second rank, one step forward, march. Full attention. Bow space.
This is NET, the National Educational Television Network.